So welcome back. I hope you all had a nice lunch. So we're now moving on to the second panel. So I will stand aside and thank you. For those of you that came specially to see Sheriff Ian Fleming, I hate to disappoint you. I'm the latest of today's substitute. It is the first time in my life, far less my career, that I've ever had to stand in for someone that's got a black belt in karate and mixed martial arts. As of last Saturday, Sheriff Fleming got both. So I would invite a round of applause, but he's not here. So I'm Lord Colbeck. I am a judicial member of the council. I've been Assessor of the College of Justice since May of this year, and prior to that I was the Sheriff Principal in Glasgow. For those of you who are interested and want to ask questions afterwards, it was me that set up the Youth Court in Glasgow. I can answer all the questions about courtrooms and why they were there. Surprise, surprise, it was all to do with resources and programming and everything else. So I, at least, if anyone has an interest in any of that, I've listened to Nina earlier on, then I would be happy to at least do some explaining to anyone who's got burning questions about it. It's for me to chair this session today. I think, like all the judicial office holders here, many cases we have to deal with involve a complex relationship between offending and mental health, and that interaction, whether it's substance abuse, homelessness, all these other factors that come into the whole mental health arena. And it's a matter that is of considerable interest to the council. The council continues to work on it. Really looking at it, to start with, the council held a roundtable discussion as far back as 2019, and of course another thing that the pandemic interrupted, involving attendees from across the criminal justice system with expertise in relation to mental health and welfare issues. And there's a report of the discussion which I'm pretty certain, Ondine, is on the website, isn't it?
Yes.
Yes, it's still there, isn't it? Yeah, in terms of it. So there's been a literature review by the Council on Mental Health and Sentencing that was published in May last year to coincide with Mental Health Awareness Week, and we're currently, if I haven't finished, just in the process of seeking perspectives of the judiciary in Scotland around the particular challenges of sentencing individuals with mental health issues, and the findings of that we will consider next year. Again, today's event and this session will be of great value to us in garnering views and listening to thoughts in terms of it. So firstly, it gives me great pleasure to introduce our first speaker. That's Professor Lindsay Thompson, who's Professor of Forensic Psychiatry at the University of Edinburgh and Director of the Forensic Mental Health Services Managed Care Network and the School of Forensic Mental Health. Professor Thompson has been Medical Director of the State Hospital Boards for Scotland since 2007. And her research interests are all set out in the summary you've got, rather than I read them out now. So, Professor Thompson, thank you very much.
So thank you very much, and thank you to the Scottish Sentencing Council for inviting me to speak today. You've heard about my roles, but I come first and foremost as a practicing forensic psychiatrist who is dealing with some of the issues that are relevant to all of us here in the audience. My day job is as a professor at the University of Edinburgh, so I'm also going to present some of our research findings. So what I'd like to go over is the links between the criminal justice and the mental health system, what we have in terms of our forensic mental health services for mentally disordered offenders, and importantly, who we have and what their outcomes are from going through that service. And then I'd like to address some of the current issues with you that are relevant in our field. And some of these you will see in italics, and that's because I know I can't possibly have the time to get to all of these, but it may be that you would like to raise some of these in the questions at the end. So this is a very important slide, and what it says is that at every stage of the criminal justice system, which will be on your left, I have powers to recommend assessment and treatment for somebody who has or is suspected to have a mental disorder. And there should be no one lurking behind a cell door, uncared for, unassessed, untreated. So right from the start with the police, they have the place of safety order, and they can bring someone usually to an accident emergency department for a psychiatric assessment. If they're already in the cells, depending on the reasons why they're there and the seriousness of that, I can actually take them out for informal treatment or under civil mental health legislation. If it's more serious and we're looking at use of low, medium, high security, depending on the nature of the alleged offence, then we may have to wait to get an assessment order or a treatment order from the court, or if you're in prison, we can apply for those through that route. And indeed, if you're out in bail under Section 200, there are powers to assess you for physical, actually, as well as mental health conditions. When we come to trial, of course, we're into the issue of psychiatric defences. But post-trial, even if you're acquitted, there's a power to keep you if you need further assessments, only for 6 hours to allow assessment to take place so that you don't just wander off uncared for but grossly unwell. If you're convicted and in prison, like any of us, you can become unwell and need mental health treatment in hospital with the power to bring you to us through the transfer for treatment direction. If you're acquitted, there's a whole range of options available for your disposal into the forensic mental health system or the community aspects of that system. And indeed, the majority of people who come to our system come on that convicted routes. They're actually found to have responsibility for whatever happened, the incident that led to the trial, but they still come to us under the psychiatric options for disposal. And if I was to show you the normal slides when I'm teaching, there are 2 slides with endless legislation. So I am not short of legislation. I acknowledge that I'm recommending to the court. For the most part, once we're out of civil, I am not applying it, but I have lots of legislation. So I can't emphasise enough that nobody should be unassessed, uncared for, untreated. Can I say, this is not a mechanism to avoid justice. The justice system goes ahead, usually in tandem with our assessment or treatment, occasionally at a later stage. We've heard mentioned today that the relationship between mental disorder and offending is a complex one. Sometimes when they come to me in high security at the state hospital, it's relatively straightforward. So I attack my mother because I believe that she's been taken over by an alien. Now, if you met my mother, you might wonder, but this is not the case, and unfortunately she ends up seriously injured because I have done that, because of my psychotic, out of touch with reality beliefs. And there you can see a very strong link between mental disorder and offending. But in fact, and I'll come on to show you, most of the patients within our service are from very deprived backgrounds, and all of these factors, social deprivation, poor parenting, low intelligence, antisocial peer group, genetic factors, substance misuse, victimisation. 50% of patients in forensic mental health services will have been assaulted themselves. And personality factors, chiefly antisocial or dissocial, all go into the mix. When I am detaining someone who is a mentally disordered offender, these are the overall criteria that must be fulfilled. Depending on the order, I've got to say it's likely or definite that they have a mental disorder, that I can do something about it in terms of treatment, that there is a risk to the health of that individual or their safety or their welfare or the safety of others. And please note, this isn't just about self-harm, suicide risk, or risk to others. It's much wider. It's their health and welfare as well. Making the order has got to be necessary, and what's different and makes the threshold lower for mentally disordered offenders is that there is no impaired decision-making ability, which is there for civil and mental health detention. And of course, the acts that are relevant to all of this are the 2003 Mental Health Care and Treatment Scotland Act and the Criminal Procedure Scotland Act 1995. Now the court, and this is your area rather than mine, is of course considering all of the circumstances of the case and alternative means of disposal, not just the mental health part, which is where our recommendations would come in. So what do we have in Scotland to look after these individuals? Well, first off, we have a forensic network. It was set up by the Scottish Government in 2003. Next month, we have our 20-year celebratory conference. It was set up to bring us together for the purposes of planning, strategy, quality improvement, education, amongst other functions. And we're divided into 3 regions, and in each of the overall regions, we have a medium secure unit. One in the southeast, one in the north, one in the west. We have one high secure hospital, the State Hospital, and then we have a variety of low secure units, some IPCUs which come into the forensic service, and there's about 22 units in total in Scotland. Each year the Forensic Network carries out a census of the patients, and I'm very pleased to say there are always about 500 patients in this service. We have not grown massively as we have seen in other jurisdictions. And the 2013, where we did follow-up detailed information, this is who we have in high, medium and low security in Scotland. They're in their 30s or 40s. The majority will be male. They're usually single, very few ongoing relationships, and most were unemployed before they came to us. Birth problems were common. They were slow to walk and talk in a quarter of cases. 13% went to special school for intellectual disabilities and 16% because of behavioural problems. And sadly, 2/5 were physically abused in childhood and 1/5 sexually abused. In terms of their psychiatric history, just over a tenth come into the forensic service as their first admission, but most are known to services, psychiatric services, before they reach the forensic stage. Everybody in forensic services is detained under mental health legislation, and 35% are for the most serious reasons, and they have the restricted patient status. On average, the length of stay is about 4 years. It ranges from a few weeks to many years. There's very few in that 30+ years. Physical health is a big problem for our patients. 73% overall of the network population obese or overweight, but can I just say that for 65% of adults in Scotland, this is also true. The further up the secure pyramid you go, the more the problems with the weight, environmentally induced often, go. 70% of our patients will have schizophrenia. We have a cohort with learning disability, and comorbid alcohol and drug problems are common. So, way back in the early 90s, and this is giving my age away, we gathered a cohort of every patient who was in the State Hospital at that time, 241, and we have followed them in the years since. Now, at that time, there was no medium secure in Scotland, so this cohort was really high and medium is how you have to conceive of it. And we have published on their outcomes, and I have one slide here. So what happened to those 241 people? Well, almost 90% left high secure care, over 50% reached the community. In terms of their symptoms of psychosis, they got a lot better. And in terms of recidivism, they did well. 22.7%, some form of recidivism, 7.9% violent recidivism, but this was largely assaults. There were no serious assaults, there were no attempted murders, there were no homicides, and there was no serious sexual offences. So if you compare to the criminal justice system, they did very well in terms of recidivism. They had very poor social and functional outcomes. No one was in paid employment, few were in voluntary employment, and there were a small number who had intimate relationships. 89 of our 241 patients died at an average age of 56, and 63 of them died prematurely. Now, we have lovely tables in Scotland from your age of birth that can say on average your life expectancy. And so we can work out that for the men, they lost 15 years of life on average, and for the women, it was 24 years of life. And there were very few suicides or deaths by unnatural means. When we compare this to follow-up studies in other jurisdictions, our rates of suicide and accidents and so on were very good. And one of the saddest parts of this research was the stigma and isolation when we interviewed the patients in the community that they felt. Not only did they have a major mental disorder, but they had all of the baggage of coming from Carstairs as well. So, on to our current issues. And a range of these are around. Firstly, the Barron Review. So, in March 2019, out of the blue, the then Minister of Mental Health announced a review of the delivery of forensic mental health services. Normally, if you get a review like that, there's been an incident, a major incident, but there hadn't been anything. And she appointed Derek Barron to lead this review, and Derek reported in February 21, slightly delayed by COVID, fair enough, and the Scottish Government responded at the end of October 21. And what they did was they set up a short life working group to consider the main recommendation from Barron, which was that we should have one health board for forensic mental health for the whole of Scotland. At the moment, all decisions of the units are taken by the local health boards. So Roundbank in Glasgow, that's Greater Glasgow and Clyde Health Board. The one special health board is the State Hospital because it has a national function. So they set up a short life working group. I sat on this group. We finished up January of this year. The report came out in August. And we are still waiting for a decision on this. From the perspective of the Forensic Network, what we want is something that gives authority and resource to move forward the issues that we face. Scottish Government are now talking about collaborative board of some description, and they say that we should have a decision early in the new year. So that's the Barron report. And all of the other 66 recommendations, it's hard to move a lot of these on until you have that first major recommendation moved. There's some areas of work that the network has taken on. Scottish Government does have a Barron review team, but we haven't as yet had output from that. So this first recommendation is causing planning blight, and we would need to see this moved on. And that comes into the issue of capacity. We do have capacity issues across the network for the patients, and this will be relevant to those of you who send people to prison. But it's not necessarily just as simple as saying build more beds. It's about log jams that you get, high to medium, medium to low, low and into the community, and that is an enormous problem. And again, if we had a decision on the primary Barron recommendation, we would know better how to plan for this. I want to then turn to mental health needs of Scotland's prisons and some work that we did. And Lindsay Gilling-McIntosh, who's in the audience somewhere, was very instrumental to this research. This was done for Scottish Government, and it involved 4 stages: service mapping exercise, what do we have in terms of mental health in our prisons, rapid literature review, quantitative modelling, how much illness is there in our prisons, and then stakeholder and lived experience interviews. So what did the prisoners say, what did the staff say? One slide on this. This just shows you the rates to your right of disorders within the prisons compared to the rates within the Scottish non-prison population. So long-term mental health conditions, about 10% in the general population, 15.5% in the prison population. And you can see that pattern repeated again and again. Self-harm, 9.5% versus 17%. Alcohol use, 14% versus 30%. And on it goes. So what we saw overall, and this is really very much in brief, was we did the mapping exercise. The resources in our prisons, in no way, they're random, absolutely arbitrary, in no way do they represent the real need. They're historical, and we need to have this sorted out. There's a lot of willingness to work on this. The Scottish Prison Service are desperate to work on this, but we need a fundamental change to the way prison mental health care is provided. 2012, it moved from the NHS, from SPS run to NHS, and it's been one of the few things you'd think that would work well, but I actually don't think it has. So we made 6 high-level recommendations and 12 operational recommendations. Overall, we said there needs to be a single model of care adopted across all of the prisons, and this could be trauma-informed. We need to make the prison environment more therapeutic. Give people meaningful activity. Don't lock them up for 23 hours a day. There needs to be an increase in NHS resources, and there needs to be models developed as to what staff you need to meet this level of need, and these need to be published. We need increased input, clinical psychology and allied health professionals. We strongly recommended the adoption of prison mental health care standards. There are existing ones, for example, from the Royal College of Psychiatrists, that could be adapted to meet our needs, and I know some prisons have already acted on this. And lastly, and crucially, there needs to be a formal partnership between the Scottish Prison Service, health and social care, and third sectors, and this has got to be empowered. At the moment, interestingly, the SPS is developing a mental health strategy, but they're not doing it with the NHS. And that way, it tells you so much, just the knowledge of that. I can see why they want it, but why do you think you can do that in isolation? Or why have they felt that they had to do it in isolation? Last issue I'm going to talk about is the Scottish Mental Health Law Review. Another one commissioned by the same Minister for Mental Health in March 2019, chaired by John Scott, now Lord Scott, and I know we have Colin Mackay in the audience, who was part of the triumvirate of lawyers, like the three Macbeth witches, Colin, who came up with this report. All 955 pages. Made great bedtime reading. You could go for the summary report if you like, but that was 154. This is a really complex, thoughtful report that raises many issues, and I cannot possibly do it justice in 1 to 2 minutes. But can I say, the Scottish Government has responded with a plan of work that's going to take us at least to 2030. There are complicated issues in it. Just even if I take the top 2 lines, and you're going human rights-based approach, absolutely, and you'll be going United Nations Convention on the Rights of People with Disability, you'll be going absolutely. And then I'll say to you, human rights requires, and we're fully signed up to this, of course, as a nation, that I need to diagnose mental disorder to be able to detain people under this legislation. The United Nations Convention on the Rights of People with Disability says it's discrimination for me to diagnose a mental disorder. So these are complex issues, and there's a whole lot of complex issues that will be worked through, and good ideas like autonomous decision making. In terms of forensics, there were 18 aspects that were relevant to us, 2 of which I've listed, and that's the court to require appropriate provision for mental or intellectual disability for remand prisoners. And I think there'll be a few people shouting hallelujah at that one. And if you live long enough, things come back. We're going to get time-limited restriction orders. When I started my professional career, we had time-limited restriction orders. And these are for people who've committed very serious offences, who, because of their risk of serious harm to the public in the future, because of their mental disorder, have these restrictions placed on them. So, I've given you today just a brief run-through of the fact that I am awash with legislation, who we have, where we have them, and what the outcomes are, and some of the issues that are really pertinent for us and that we're hoping to move on in the future, and some incredibly important that I haven't had time to discuss. Thank you very much.
I'm sure the judges in the audience are happy that they are washed with legislation in mental health. It's no truer point to me. Our second speaker in this session is Dr. Alva Laughlin. You let me be delighted to know how to pronounce that properly.
Yeah, yes.
In relation to it. So, Alva is a senior lecturer at York Law School at the University of York, who's going to be talking to us today about sentencing and mental health from the experience of England and Wales. Amongst Dr. Laughlin's researchers, she's done work for the Scottish Sentencing Council. So, thank you very much.
Okay, thank you. So I've got slightly differently formatted slides that I'll open up separately. But yeah, thanks very much for the invitation to speak today. I'm really excited to be talking about mental health and sentencing today, and sharing some of my research with you, which is mainly focused on England and Wales. But because I did work on the sentencing literature review for Scotland, I do have some more kind of background, say, in England and Wales, where I'm familiar a bit more with the Scottish system after doing that as well. So I'm going to try to link what we're looking at in England and Wales with the system in Scotland as well. So my research generally, so I focus up until now really at looking at the case law from England and Wales that's come out of the Court of Appeal, and also at the sentencing guidelines that came out in 2020. So I'm mainly going to be drawing on some of the ways in which mental health law has been applied by the courts in England and Wales, and looking at ways in which it could perhaps be improved or done differently. So those guidelines, so they entered into force in England and Wales in 2020. So we have had a few cases come out since the guidelines entered into force, and I'll be talking about some of those. And the Court of Appeal case law, so prior to the sentencing guidelines and also after the guidelines have come out as well, the case law tends to focus on more serious cases. There's been quite a number of cases brought by people who are patients in the psychiatric system who were serving prison sentences, who were given prison sentences and then were later transferred into the hospital system. And so a number of people, have brought appeals against their original sentence based on fresh evidence of their psychiatric disorders and the treatment available for them. So that's where a lot of these cases have come from. There are also some cases which are based on, more recent sentencing decisions where people are appealing against their sentence based on it being, overly harsh, or the psychiatric evidence not being fully taken into account. So we also have those cases as well. And the case law, so some of it did influence the sentencing guidelines. And in some ways, there are some issues with that, in that because of the way that those cases came to the Court of Appeal, they were these types of appeal cases. So there's a tendency in the Court of Appeal cases to focus on the high end of sentencing, to focus on the choice between a prison sentence and hospital disposal, so as the sorts of disposals that Lindsay was talking about. So we have less case law available, on the choice between a prison sentence and a community order with a mental health treatment requirement. So that, again, is a really important way of filtering people out of the prison system, and the kind of custodial system is for them to have treatment in the community. But I'm going to be focusing mainly on the case law looking at the choice between prison sentences and hospital orders, and also the choice between hospital orders and hybrid orders, which is kind of a combination of a prison sentence and a hospital disposal. So I'll explain a bit more about that as we go through. So what I found in the research, looking at these sentencing cases or the appeal cases, is that courts are sometimes borrowing concepts from the trial stage at sentencing, particularly to determine culpability, and that there are some cases where less weight is given to concerns about the person's welfare or therapeutic interests. And the sort of argument I'm going to make is that these types of disposals, so the hospital disposals, they can play a really important role in diverting people away from prison, where prison is likely to be harmful to them, but they can also play a role in community reintegration as well, because if someone is on a hospital order, their track to going back into the community is very different to the track that they would be on if they had a prison sentence. So I'm going to be going through some of that as well in my 15 minutes. So it's going to be a slightly whistle-stop tour. So hospital orders, which I've mentioned already, so there's hospital orders with restrictions. They're comparable to compulsion orders with restrictions in Scotland. So in Scotland, it's possible to make a compulsion order that mandates treatment in the community. We don't have that in England and Wales. In England and Wales, it's mainly hospital orders without restrictions or hospital orders with restrictions, where someone is sent to hospital for treatment and they can receive treatment there without their consent. So that's one of the main differences between hospital detention and detention in prison, is that if you have capacity, you can't be treated without your consent in a prison, whereas you can be in a hospital. And there's also the hybrid orders, as I mentioned, so it's a combination of a prison sentence and a hospital order. And the legislation, so I'd say kind of here, in Scotland as well as in England and Wales, there isn't much legislative guidance on how to choose between a hospital order with restrictions and a hybrid order, so this combination of prison and hospital. And the criteria for making these orders are really very, very similar. So you need psychiatric opinions, so 2 psychiatric reports that support that the criteria are met for a hospital order. And the criteria for a hybrid order, so say the hospital and limitation direction, the criteria are basically the same. So the psychiatrists need to say that pretty much the same criteria are fulfilled. So it poses a problem then. So how do judges then choose between those orders? And the effects, as I set out in the slide, they're very different. So particularly in terms of release and what happens to the person afterwards. So with the hospital order with restrictions, they go to hospital, and then their pathway kind of into the community is through the hospital systems. They can kind of move down through different categories of security, maybe starting in the high security, working their way down, and then they're discharged into the community via the mental health tribunal, applying tests of whether they're still in need of treatment or not, if they still warrant detention in the psychiatric hospital, and whether they still pose a risk to the public. Whereas if they receive a prison sentence and a hospital and limitation direction, their journey back into the community really depends on that prison sentence. And you'll have the involvement of the parole board if they're serving a life sentence, and they can't be, say, released directly into the community without the prison sentence, say, being taken into account. And there's also the issue of recall as well. So generally, if someone is a restricted patient, they're monitored in the community and they can be recalled back to hospital if they meet the criteria for detention in hospital. So again, it tends to be deterioration in their mental health, plus perhaps risk to the community. They can be recalled. Whereas if someone is on a life licence, it's a much more public protection test. And if they're recalled from the community on a life licence, they tend to be recalled to prison. So you could end up with somebody who has kind of worked their way out into the community via hospitals, then being recalled back to prison. So there's lots of kind of issues there as well. So we've seen kind of a movement in the, say, the sentencing case law. So the earlier cases in England and Wales, they tended to prioritise hospital orders. So where the criteria were met, there was a tendency for the courts to recommend a hospital order, say, rather than a prison sentence or another type of disposal. But then over time, there's kind of been an evolution towards, say, prioritising public protection, but also culpability and punishment, risk to the public. And so this sort of culminated in the judgment of Voles in 2015 by the Court of Appeal. And this judgment, so it was criticised for seeming to prioritise hybrid orders. So for seeming to say that we should be prioritising hybrid orders over the hospital orders, and also for focusing on punishment and culpability and seeming to kind of put that ahead of the therapeutic interests of the individual. So after Voles, there has been a bit of a retrenchment in the position of the Court of Appeal on this. So in Edwards, it was sort of they advocated a slightly more flexible approach, but there was still this idea that a prison sentence or, say, a penal element is sort of required in sentencing, even if somebody has a mental disorder. So in Edwards, it was said that sound reasons would be needed to depart from that sentence with a penal element. So again, the court in Edwards seems to be promoting the combination of prison and hospital rather than a hospital order. And we've also seen borrowed concepts as well. So one thing I've noticed in the case law is that both in the lower courts and sometimes in the Court of Appeal, there's a tendency to borrow from, doctrines that we tend to see at the trial stage, like insanity and diminished responsibility, into the sentencing stage. And that happens even where those doctrines were not applicable. So say in Voles, they tend to use the reasoning of diminished responsibility, looking for a causal connection between the disorder and the offence, and looking for a causal connection between the risk of reoffending and the disorder. Whereas actually in Voles, none of the appellants in that case would have been able to raise diminished responsibility because none of them had been charged with murder. So it wasn't available. So it seemed as though the court had kind of borrowed this diminished responsibility kind of reasoning from the trial stage, probably through the case of Birch that I mentioned earlier, which was a case involving diminished responsibility. And then we've also seen in other cases, so again, kind of pre the guideline and post the guideline, sometimes lower court will send sentencing judges using the reasoning of insanity to determine culpability as well. So saying things like, you knew what you were doing at the time of the offence and you knew that it was wrong, therefore you're culpable and therefore a prison sentence, say maybe combined with a hospital and limitation direction is sort of required. So we tend to see in some cases kind of quite, reasoning that's not quite inflexible reasoning, this sort of idea, well, you're not insane, you therefore are culpable, we're therefore, warranted, or we should give you a penal disposal, even though the sentencing, the actual legislation doesn't say that is required, that we have to take that approach. And these doctrines, they tend to be very inflexible, so particularly insanity, as we mentioned earlier by Lindsay, very, very few people are found insane because the criteria are extremely narrow. In England and Wales, it's only about 30 people a year found insane. So if we're applying that doctrine at sentencing, we're likely to exclude a hell of a lot of people from the hospital orders. We're likely to really narrow the scope of those orders. And similarly with diminished responsibility as well. So the problem with that is that under diminished responsibility can't be entirely excluded. It can only be diminished. So we've also seen kind of logic as well where, okay, your responsibility is diminished, but it's not excluded. Therefore, again, there's culpability, therefore punishment is required. So there's a problem here with this type of reasoning can then exclude people from hospital orders, even though they might be, in the interest of their welfare, so where imprisonment might be detrimental, or also where it might be in their therapeutic interests. They're more likely to get the right type of care and treatment in hospital rather than in prison. So it can be problematic. Okay, I'm going to have to whiz through the last couple of bits. Yeah.
There's so much time for questions.
Okay.
For some reason, take your time.
Okay, great. Yeah. I won't overdo it, but yeah. Okay, so I have a couple more slides to go. So following on then from the case law from the Court of Appeal, the sentencing guidelines, so from 2020, there is some mention of the ideas in Voles particularly and in Edwards about assessing culpability, but the sentencing guideline takes a more flexible approach than what we have seen in some of the case law. So in the guideline it says that culpability will only be reduced if there's a sufficient connection between the offender's impairment or disorder and the offending behaviour. So whereas in Voles, and to some extent in Edwards, there is more of a focus on a causal connection. That has sort of been attenuated in the sentencing guidelines, and I think, as Lindsay mentioned as well, it's very difficult to really determine a very strong causal connection between a mental disorder and the risk of reoffending. So, kind of making that the bar probably sets it too high and makes it very difficult. Again, will tend to exclude people who might benefit from those types of disposals from receiving them. And the other aspect of the sentencing guidelines that is really important as well, and I think has been, a really good development, is that it draws attention to the impact that a prison sentence can have on the defendant. So taking into account the fact that they might experience a greater level of punishment because of their, vulnerabilities, that they might experience a prison sentence as being a harsher form of punishment than someone who didn't have those vulnerabilities. And we can also take into account, again, the impact on their mental health as well, whether it's likely to deteriorate, whether it's likely to have an impact on their mental health in prison. But the guideline says that these things can only be taken into account in a limited way, whereas I think that we could draw on principles from human rights law to kind of give us a more, comprehensive set of guidelines on when we might be warranted in departing from the prison sentence, as the usual course. So I'm going to flesh that out in a few minutes as well. So we see kind of similar ideas in the Scottish Mental Health Care and Treatment Act Code of Practice as well. So there's an idea in that a compulsion and restriction order would normally require a significant link between the offence and the disorder, and for the disorder to play a substantial part in determining risk to others. So here we see a similar idea that, again, perhaps culpability is more likely to be reduced if we have that significant link between the offence and the disorder. And also the idea that if the disorder played a substantial part in the offending and in their risk of reoffending, then treatment is more likely to reduce their risk to the public. So again, that would sort of send people down the therapeutic route or the hospital route. But there are problems here with cases in which, so I have a couple of examples of this, cases in which there was not such a strong connection between the mental disorder and the offence, or also cases in which the risk might not necessarily be so closely linked to the mental disorder, but where it would be detrimental, particularly to the defendant, to receive a prison disposal, and again for the possibility of that person, even if they were to receive the hybrid order, for them to end up in prison later on, because that's always kind of a risk really with the hybrid order, is that the prison sentence stays running and they could be transferred to prison or they could be recalled to prison at a later date. So two cases in which we've seen sort of more of a flexible approach or more flexible approach from the Court of Appeal. So in the case of Khan, so in Khan, the appellant here, he'd committed offences of fraud, so defrauding the public revenue, I think it was. But those offences, they were completely unrelated to his mental disorder. He wasn't unwell at the time that he committed those offences. But his mental disorder significantly deteriorated when he went to prison, and he became suicidal, and he basically, the risk he posed to himself couldn't be managed in prison, so he was transferred to hospital. And in that case, so again, if we applied the sort of Vohl's reasoning or these requirements for a significant link between the disorder and the offending, we might say, well, we're warranted in maintaining the prison sentence here because he's culpable. There's not much of a link really between the disorder and the offending. But the court ruled that culpability could not be determinative of the disposal given the really serious risks that he posed to himself, and therefore they should substitute a hospital order for his prison sentence. And then in Miller as well, we saw consideration of the release provisions as well, and the risk that the person could end up being recalled to prison if they were to remain on this life sentence. So in that case as well, they also substituted it for a hospital order. So in these cases, we didn't see human rights principles being invoked, but I think that we can say retrospectively justify them on that basis, that, even if somebody is culpable, we should take into account if in prison poses a really serious risk of harm, so a really serious risk of death, of serious self-harm, then we are warranted in departing from a prison or a punitive order, even if they are culpable. And these principles would support that approach. And I think that could kind of be a better sort of structure as well for determining these types of cases. And say another reason to depart from this idea of needing a significant connection between the disorder and the offending. And I think these cases also tend to reinforce the need for clarity as well for sentencing judges on the possible consequences of different orders. So something I've noticed in the case law is that you see very different evidence on what the likely outcome of these different disposals is likely to be. It tends to draw on the psychiatric reports, it tends to be cross-examination of the psychiatric witnesses, and we don't really have a very clear idea in some cases of what will actually happen to this person if they receive this disposal or a different disposal. So thanks very much. That brings us to